see if I can get it on the right screen.
I can see your opening slide.
Oh, great. Okay. So thank you, Jeff, for the introduction. For those of you that don't know me, again, my name is Heidi Seaton. I'm VP of Legal and Compliance here at Orange Tree. I've been in background screening now for 20 years, and in one role or another, most lately focusing on legal and compliance. So that's what we'll talk about today. Jeff did cover this next slide. I do like to stop here and just remind people, I'm not your lawyer. This is not legal advice. I always recommend that you seek the advice of your own legal counsel for anything related to employment, background screening, or any other specific legal questions you have. That said, for those of you who regularly attend the webinar, I'm switching it up this quarter. I'm going to talk about national developments first, and then we'll move into some things happening more at the local and state. And of course, the reason for that is just because so much of what we're talking about and dealing with today as employers, as a background screening company, relate to working through this time of COVID-19. So I know for customers, our client success team has been keeping you in the loop on what's happening out there in the world of courts, with employers, with schools. But just to give a quick update, we are seeing sort of an interesting trend here as we had a lot of court closures happening in March, April. Things started to open up a little bit, May, June, and then we're seeing a little bit of a turnaround there again here, July, August. It's not bad at all right now. We've got, by my count, something like under 20 court jurisdictions currently closed. So for instance, Georgia has 10 courts that are closed, Kentucky 2, Michigan 1, Mississippi 3 or 4 as of this morning, Tennessee 2, and West Virginia 2. What we're doing though is in most of those states, so Georgia, Kentucky, Georgia, we were already doing it, but we do have a really good statewide option in those jurisdictions where those courts are closed. So we're just going ahead and moving forward and doing those statewide searches where we can. The example of one where we can't was New Jersey. So we're going to talk about New Jersey because we actually have a breakthrough there. And then West Virginia, we recently had a couple of courts close here, and so we're holding on those because they don't have a great statewide option. And then just to be clear, what we're seeing is sort of intermittent court closures now. So it tends to be a particular court location where maybe they had a court clerk or an employee who tested positive, and so they have to close that court, do some cleaning or do a quarantine, and then they tend to reopen. So we are seeing some closures, but we're seeing fairly good movement getting them back opened again. So we kind of expect that to continue. West Virginia, like I said, just 2 courts right now that we're just holding open. Hopefully those 2 will also reopen here as things improve in those particular courts. New Jersey, as many of our clients are aware, they closed their public access terminals and public viewing rooms early in the pandemic. And so we've been working, the PBSA, the National Association, has been working with the courts to see if there's any way for us to begin to access an online system there. And we did hear earlier this week, last week, that we received word that the Office of the Court Administrator would be expanding their electronic access program to include criminal cases. And so that's great news. We were able to get access, our researchers were actually able to get access earlier this week As of today, our researchers are able to access the system and we're testing. So you can imagine a significant change in how criminal records are done in New Jersey. So we do need to do some due diligence, make sure that the information we're getting through that online site, online access, has all the information that we normally get through an in-person search. So we're testing. We actually do expect to actually start receiving real results and reporting out real results as early as this week. So more to come on New Jersey. The client success team has been keeping our customers in the loop there, but we think that's a really, really good outcome. It'll be really interesting to see, by the way, whether that's something the courts will allow to continue when and if there's a change with the pandemic, right? That might be one of an efficiency that actually gets created out of it. So very interesting to be watching that. On the topic of COVID-19 and background screening in the time of COVID-19, just a good reminder for employers, if you haven't been thinking about it, now's the time. It's not too late. Consider if there's anything in your offer letter that maybe needs to be tweaked. So sometimes offer letters just talk about that the offer is contingent upon completion of the background screen. Maybe it's language that's more like the offer is contingent upon successful completion of a background screening program, which could be completed before or after employment, right? Which would allow you to do some additional post-hire screening or additional screening as courts come back online if you decide you want to move forward with hiring someone. We're also, I'm hearing out there employers who are inserting something like an honesty clause into their offer letter language. So some language that would allow for an employer to terminate post-employment if misinformation or perhaps omissions are uncovered once standard screening protocols are reinstated. So a couple of options there for employers to be thinking about in their offer letter language. Also be thinking about documentation. We've actually had pretty good results here with employers or schools where they might have been closed down or moved people to a work from home situation. We've actually still had pretty good responses from employers on providing employment verification or education credential verification. But what I do sort of expect to start to see here are maybe as the pandemic extends, we might see some smaller employers or employers that will not recover from what's now an economic downturn. And so we might have employers where there's no longer an employer for us to be contacting, especially small companies. So be thinking about if it's time in your policy to be looking at whether in some cases, under some circumstances, accepting documentation or Orange Tree collecting documentation on your behalf might be appropriate. And then Jeff had mentioned, but just another thing for employers to be thinking about in this time are your employees that are working from home. Is there some sort of monitoring that might be appropriate? Maybe current county or some sort of national criminal record locator service, just to keep tabs on, do you know what your employees are doing when they're at home? It's a little harder, we all know. I think we've experienced a couple months of this now. We all know it's really harder to supervise employees when they're not here in the office. So something to think about for work from home employees. And then for returning workers, if you've done furloughs, if you've done layoffs, I would think employers need to be thinking about their policy related to rescreening, right? Is it been long enough that now your policy requires a new background screen? Does it need to be the full package again, or maybe it's just criminal searches again? Is this a good time if you're rescreening or rehiring or bringing people back from furlough? Is this a good time perhaps to make those FCRA disclosures again, get the FCRA, Fair Credit Reporting Act, authorization on file with an updated date? Is it time to be looking at your disclosure or your authorization language to see if you want to add some sort of evergreen clause that makes that disclosure or the authorization to do the background check effective not only pre-employment or as part of the hiring process, but then ongoing as your workers are returning to their jobs. which would sort of help with continuous monitoring some of the products that Jeff was talking about. So just some things to be thinking about. Also, in this time of COVID-19, we're seeing a fair amount of action from enforcement authority or agencies. So the Federal Motor Carrier Safety Administration, so that's safety sensitive driving regulatory agency, provided a notice of enforcement discretion here earlier in June, so earlier in July. And it's related to specifically to random program management. So the enforcement discretion notice covered issues with employers making sure that they have the minimum annual percentage rate of drug and alcohol testing happening. So the FMCSA regulations this year require DOT or regulated employers to random drug test 50% of their employees and alcohol test 10% of their employees over the calendar year. And so they said that they might allow for some enforcement discretion around, did the employer make those minimum annual percentage rate drug and alcohol tests, did they complete them? And then there's also a requirement under the regulation for the dates of the testing to be spread reasonably throughout the year. So you can imagine in a normal year, this is easier to do, right? Your people are in the office, your drivers are reporting to work. You regularly, maybe monthly, sometime during each month, do the draw, get the people that are drawn out for their collection and get it done. Harder to do, right? If you're having intermittent or prolonged driver furloughs, if you've laid drivers off. If your drivers just simply are not available to you to be in that or to participate in that random draw process. So the notice does make it clear that if the employer is capable of meeting the requirements, they have to continue to do so. So it's not a get out of jail free card. It's not a crutch. And they urge employers to continue to do their selections at the required rate, to do their selections reasonably throughout the calendar year. But then if there's some specific reason for noncompliance, so if the employer it doesn't look like they're going to meet their rate, or if they're not able to do the collections reasonably throughout the year for whatever reason, they're going to be looking for documentation of the specific reason for noncompliance. So they'll be looking for, for this test, for this draw, was there a closure? Was there an issue with finding a collection site? Was there an issue with getting personnel at the collection site? Or was the issue with the fact that the driver was furloughed or had been laid off? So it's good news, I think, for DOT regulated employers. It gives them some breathing room around their random programs and making sure that they're meeting those requirements throughout the year. From Orange Tree's perspective, we have not experienced a ton of issues with collection sites being unavailable. Generally, the collection sites are still available, they're open. If anything, we might see, reduced hours of operation or reduced hours of when they will do a drug test or an alcohol collection. But generally, for the most part, our clients are not telling us that they're experiencing issues with getting those collections done. So be careful about that third bullet, right? The FMCSA is going to look closely at whether or not the employer was capable of meeting the requirements or not. That will be the first hurdle the employer has to reach in order to be subject to this enforcement discretion, I'm guessing. By the way, that was FMCSA only. I have not seen anything of the like for any of the other DOT sub-agencies. So if you're regulated under some other agency of the DOT, I'm not seeing that discretion, at least it hasn't hit my radar yet. And then another sort of notice or announcement from federal agency, the Department of Homeland Security announced prosecutorial discretion related to the requirement for physical presence on the Form I-9. So just to step back a tish here, the Immigration Reform and Control Act, that was 1986, requires employers in the U.S. to complete the Form I-9. It's called the Employment Eligibility Verification for all new hired employees, and it is to verify their identity and also their work authorization, and it has to be completed both by employers and employees. So this announcement from DHS provides for some discretion around that physical presence requirement of Form I-9. So normally, under normal circumstances, when the employer is completing the I-9 form with the employee has to be in person. They have to provide their identity and work authorization documents to the employer in person. The employer looks at the person and the identity document and tries to confirm, yes, this document does appear to relate to this person that's sitting in front of me. And it's really just that in-person requirement that they have provided some discretion around. But do please go to the DHS and read the announcement closely. They have provided guidance for how they want a Form I-9 notated when you're doing a remote inspection. They've provided guidance on how to perform that physical inspection later once normal operations resume. So it's important that you be familiar with that before you just go do a remote I-9 form process. And then just a couple of other notes. The DHS did announce also some visa flexibility guidance, so mostly related to the H-2B and the H-2A permits. They also have provided some flexibility for documents, the List B documents that expire, and how that works will depend on whether or not the expired List B document, whether the agency that issues that document has extended the expiration date or if they have not. So again, pay close attention to those rules. And it also provided some, for employers that participate in E-Verify, some extended timelines for the tentative non-confirmation process. So be careful with that as well if you are an employer that participates in E-Verify for the Form I-9. The last topic, kind of a big one, but by that I just mean broad. You, I'm sure, have been following the Coronavirus Aid, Relief, and Economic Securities Act, also known as the CARES Act. It was a $2.2 trillion economic stimulus bill. It was passed in March. And little known fact, it included some rules for credit bureaus related to their dispute process, related to if they're making, also to furnishers, related to furnishers if they're making accommodations or forbearing some debts. So there was, the CFPB then issued a set of FAQs around how they intend to supervise and enforce FCRA under CARES Act. And so credit bureaus, especially furnishers, information furnishers, debtors, basically, who provide information to credit bureaus, have been paying a lot of attention to the CARES Act. Had very little effect or impact on employers and the employer's use of credit in the background screening employment arena. But we are now closely watching the HEROES Act. So that's the Health and Economic Recovery Omnibus Emergency Solutions Act, because it amends the CARES Act, and it was already passed in the House in May. It's making its way through the Senate. It's in committee They're holding hearings. Unfortunately, the HEROES Act is less well drafted than CARES Act was, because the HEROES Act talks about a consumer reporting agency instead of a credit bureau or a credit reporting agency. And so I think perhaps somewhat unintentionally, but maybe not, it includes language that is a lot more broad. And it includes, I quoted it from the bill here in this last bullet, information that's not directly related to credit. So it's broader. It says no consumer reporting agency may make any consumer report containing an adverse item of information except information related to a felony conviction relating to a consumer that was the result of any action or inaction that occurred during a covered period. So trying to figure out what is intended by that as it relates to other adverse information that regularly makes its way into consumer reports for an employer, right? So think about information about from an employment verification, a professional license, public record action, according to this, a misdemeanor conviction, or information any action or inaction that occurred during the covered period related to a misdemeanor. So problematic language for employers. If you haven't, consider reaching out to your representatives on this one. I'm guessing that some part of HEROES will pass. I am still hopeful that this particular language will get some attention. We'll find out, right? I know that the PBSA, the National Association of Professional Background Screeners, has been lobbying and has been in communication with the Senate and the committees about this. So hopefully we will see some change there before it just gets blindly passed. So moving on to state and local topics, we'll go to ban the box, our favorite topic as we talk about background screening, employers, their consideration, especially of criminal history information. Again, remember, ban the box is that effort started years ago with removing the criminal history question from the employment application. That was the box that was banned. And in some cases, it now restricts when employers can do the background check and create some additional obligations sometimes for employers. It's evolved into what's becoming known as a fair chance legislation in some cases, or now also it sometimes just gets thrown into criminal justice reform or decriminalization efforts or laws. So more on that with a couple of the other jurisdictions, but we'll start in the Midwest. We've got Waterloo, Iowa. So this one was effective July 1st. It made it an unlawful discriminatory practice for an employer to make an inquiry or require disclosure of convictions, arrest, or pending charges during the application process. And then further, it says an employer also may not make an adverse hiring decision based solely on an applicant's arrest or pending charge or an erased or expunged record without a legitimate business reason. So kind of going back to school here on policy, this is a good reminder of how important it is to have a background screening policy, to ensure that the policy includes sort of a consideration if you're going to consider criminal history information in your employment decision, that you've identified how a criminal history record would be job related or a business necessity for your particular company. And notice, so again, here in Waterloo, the first bullet is about convictions, arrests, or pending cases. The second bullet is about pending cases or erased or expunged records. So arrest records, pending cases, erased or expunged records. So generally, a background screening company is not going to report arrest-only cases, and we're also not going to report an erased or expunged record. But many, many employers do ask us to provide information about a pending charge, right? That employers generally consider that to be a legitimate something that they need to know. And so if you are in Waterloo, Iowa, you want to be thinking about how to make the case for whether a pending charge is job related or where there's a legitimate business reason for you to use that information to make an adverse decision. Moving out to Suffolk County in New York. So again, local ban the box ordinances. We see these happening at the city. We also see them happening at the county level. This one goes into effect August 25th of 2020. It is applicable to private employers. And it's employers with 15 or more employees. And it says employers can't make an inquiry regarding or requiring any person to disclose criminal conviction during the application process or prior to a first interview. So if you're employing people in Suffolk County in New York, you want to look at your processes to make sure that you are not asking about criminal conviction or doing an inquiry into, which would be running the background check, until probably after the first interview, or if you don't do interviews, you want to make sure it's definitely after the application process is completed. As these ordinances and laws do, this one has a whole list of exceptions. So it's identified police, fire, rescue, emergency services, people in the public or private schools, employers that are have employees that are providing direct access to disabled individuals or caring for children or other vulnerable populations. Back to the Midwest. Sorry, I don't know what my order was this time. St. Louis got a little time on this one. It's not effective until January 1st of 2020. It is also applicable to private employers, and it says employers may not make an inquiry about an applicant's job history until should say criminal history, until after it's determined that he or she is qualified for the job. If the applicant's part of a pool, the inquiry can be made, but only if it's a final pool and only if the question is asked of all members of that pool. Again, similar to Waterloo, employers may not base their hiring decision on an applicant's criminal history unless the employer can show that the history is relevant to the duties of the position. So again, start documenting the job responsibilities of your positions. And it also includes a fair number of limitations on how the employer can advertise or talk about positions. So they're not allowed, an employer's not allowed to publish written or electronic job advertisements that exclude applicants on the basis of criminal history. They're not allowed to include a statement statements that exclude applicants on the basis. And they're not allowed to, they're also not allowed to seek or obtain publicly available information concerning a job applicant's criminal history, again, until after they have determined that the applicant is qualified for the job. So that is effectively limiting not just when the employer can ask the applicant about their criminal history, but also publicly available information concerning job applicants' criminal history. That would be social media. If you're an employer that looks at social media sites, that would be the criminal background check itself. So have a care about that if you are in St. Louis. And then moving from local to the state level, we talked about Maryland last time. I did an update, but you may remember in January, early in 2019, Governor Hogan had vetoed the Criminal Record Screening Act, the 2019 Criminal Record Screening Act. in January of 2020, the Maryland Assembly overrode the veto. So this law will go into effect, or did go into effect. It was effective February 29th of 2020. It's applicable to, again, private employers with 15 or more full-time employees. And Maryland employers cannot inquire about an applicant's criminal history before the first in-person interview. So pushing it out to the interview process. And then just as a reminder for those of you in Maryland, in some of the high population areas, Montgomery County, Prince George's County, the city of Baltimore, all have even more restrictive ban-the-box limitations. So those would still apply. The state law didn't attempt to preempt any of those local ordinances, so you should be thinking about both if you are in Maryland. I think that's all I have to say on that one. So a slightly different twist or taste going on in Pennsylvania. Senate Bill 637 was passed and signed by Governor Wolf. It's actually a decriminalization or criminal justice reform bill, and it's aimed at improving occupational licensing boards. So coming at it from a different angle than trying to restrict what employers do. But basically, there was 5 improvements for occupational licensing boards. They can no longer use a person's criminal history to deny someone a license unless that history is directly related to the occupation with which they're seeking to be licensed. The board has to individually consider applications based on the offense. They have to take into consideration the time since the conviction, their personal progress in training, and other factors before they decide to withhold. They have to create, each board has to create a public list of criminal offenses that would prevent licensure by that board. And allow individuals to get a preliminary decision on whether their criminal conviction is likely to disqualify them, so that they don't inadvertently waste time and money, get training, and perhaps pay for a degree, and then find out at the end that they can't be licensed. The law also creates a temporary licensing process for some prison reentry programs, so especially related to barbering and cosmetology. So an interesting approach coming out of Pennsylvania. Related to ban the box, but more about decriminalization. Georgia passed Senate Bill 562. It was signed by their Governor Cooper, and it's a Second Chance Act. And so it makes many misdemeanor convictions eligible to be sealed 4 years after completion of the sentence. So it has some exceptions for certain types of crimes, so drunk driving, family, domestic related, family violence crimes, stalking, sex offenses, things like that. And it does require a petition. So if you want to move to have your misdemeanor record sealed, you have to petition the court for it. It's not an automatic step. But a significant change in Georgia, where previous to this law, criminal records tended to stay in the system for many, many, many years. So it'll be interesting to see how many people move forward with petitions to seal, how quickly the court is able to move through those, and the effect that that could have on employers. The sealed records would still be visible to police and court, but they would not be available to employers. So I'm guessing there will be some exceptions that will get worked out there, but I didn't see anything in the language of the bill itself, except for those exceptions that are identified by the type of crime. And then last one, this one's pending. It's just a Senate bill introduced into a conference committee in Mississippi. So we'll keep an eye on that one, but it just basically the language would remove the presence of a prior criminal record as a preliminary bar to employment. So we would see how that particular language will shake out and whether or not it actually makes it through the legislative process there. And now I know I'm looping back here to the national theme, but just for a minute, we also on the topic of Ban the Box have this bill that was introduced. It's called the Workforce Justice Act. It was introduced by Representative Trone from Maryland, and also Chairwoman Maxine Waters. She's the chairwoman of the House Financial Services Committee out of California. And this is one of those nationalization of Ban the Box acts that we see. We see a couple of them every year. In this case, it would require states to enact Ban the Box policies prohibiting employers from asking applicants about criminal history prior to the offer. And it links for an employer, for each state, it links implementing such policies to receiving criminal justice reform funding from the federal government. So likely to push states into creating these sorts of statutes or policies if they haven't already. It's basically an extension, or it's very similar to the language used for last year's Fair Chance Act, which applied only to federal agencies and contractors. This one would apply to private employers. So we'll keep an eye on this one and a few others. They'll get introduced at the national level. In some cases, a national standard would actually be welcomed by employers, right? A multi-state employer is potentially having to concern themselves with complying with a set of Ban the Box requirements or multiple Ban the Box requirements at the state, the county, and the city level. There's already 14 states that have legislated Ban the Box for private employers, many hundreds at the county and city level attempting to do that. So you can see actually where a national standard would actually be helpful for employers. But the important pieces we'd be looking for in a national standard would be preemption, right? So you'd want to make sure if such a law was enacted at the federal level that it would preempt all the state and local Ban the Box policies and laws and ordinances that are already on the books. And then I think also importantly, you'd be looking for the sort of national level Ban the Box to also be, to have exceptions, right, at the state level. So right now, like the federal Fair Chance Act has an exception for employers who are hiring into positions where there's federal law that says that limits who can take those jobs based on, who can have those jobs based on the kind of criminal history that they have. So I think employers for a national Ban the Box for private employers would also be looking for that sort of exemption or protection at the state level too, right? We know that there are many industries like healthcare, childcare, education, where the limitation of who employers can hire is baked into either state statute or regulation. So again, we'll keep an eye on this. I actually think this one is less likely to pass this year. I think there's just too much going on, but we will keep an eye on it and let you know if we see anything happening there. So that is my last slide. As Jeff noted, I'm happy if you want to reach out to me if you have particular questions. My contact information is there on the screen. For our clients, you always have access to your customer care consultant. They can get questions to me as well. And Jeff, I think you said that we would attempt to take some questions here at the end. If I can come up with answers on the spot, I will.
Well, we're going to put you on the spot. We have a couple of questions this afternoon. How do you think?
If you have questions.
For presentation. We have our first question is on I-9. The question is several parts. Maybe I'll just take it one part at a time. Can we use a notary to verify legibility of the document and sign saying this person was present with this document and is the person listed?
I don't know the answer to that question. I would have to look at the particular guidance that came out on that question, especially related to remote. There might be something there even for non-remote, but generally, I think I'd want to dig in on that guidance.
Okay, then maybe what we'll do is just hold the other parts, and we will send a follow-on email then
Sure.
to the person asked the question. The question, I think this was related possibly to St. Louis, and the question is it a correct understanding that even mentioning a background screen in a job ad could be problematic in some jurisdictions?
It is. Trying to think. I don't remember seeing that. Oh, yep. I'm on the wrong slide. Hang on. Let me just go back to my notes. I think you're right. I think St. Louis would be one of those where I'd be really careful about what you put in an ad. It seems like they are really trying to lock down any mention of passing a background check prior to that determination that the person is qualified for the job. If you want my opinion about that as a policy decision, I actually feel like it's the wrong direction, right? Most employees or applicants want to be able to talk to you about it because there's nothing more disappointing than getting that offer and then finding out that you're not qualified due to the background check. And so I think I think it's not a great policy, but the people in St. Louis did not ask my opinions, and maybe you didn't either.
Okay, thank you, Heidi. I mean, more broadly then, I know this is on your slide here related to St. Louis, Missouri. Is there momentum in other parts of the country? Are there other specific, I mean, should we be aware of it more broadly than this?
There are a few. I think New York City has a limitation off the top of my head. I can think of that one. It's not that common actually that the legislation touches on the topic of advertising for the job. And so when it does happen, it tends to sort of jump out. Usually when we hear about it, we talk about it in this sort of presentation just to put the employer on notice so they can go look and see what the particular limitations are.
Okay, very good. Next question. Do we have insight as to when the New Jersey courts will resume?
Well, we think we'll get access to New Jersey court record information as early as, I shouldn't say it, but as early as today, maybe tomorrow, certainly this week. When actual court proceedings will resume, I have less insight on that. I think we'll just have to wait and see what the courts decide to do there.
Okay. Next question, does the FCRA policy need to be included with the application for employment if you are only running DMV background reports?
Sure. So I think the question is whether the Fair Credit Reporting Act applies to an employer that's only running a driving record search. And it's a legal question, so I'm going to tell you to check with your own legal counsel. But in general, a consumer report is a report that bears on a consumer's, now I'm going to forget the quote. I would say yes, it's about characteristics, it's about, it's information about that consumer. You're going to use it to make a hiring decision. And if you're getting it from a third party, a background screening reporting agency like Orange Tree, then it seems very likely that the Fair Credit Reporting Act does apply.
Okay, I think that concludes our questions at this time. Heidi, thanks for answering those on the fly. I appreciate it. Well, I think there was one where we'll look into a little bit, and I-9. We'll follow up on that a little bit, provide some additional context. And I know there were other parts that individual asked a question. There are a couple of other parts. We have the total set of questions here. We'll look into that and respond to each of those and make sure that you get what you're looking for. So that concludes today's webinar. Thank you for joining us here at Orange Tree for our third quarter compliance update. If you do have additional questions that come to mind, feel free to email your client success partner or contact us via our website. It's a very simple, easy to use contact us form, and we'd be delighted to respond as quickly as we can with the information that you're looking for. So with that, everybody, thank you and have a great day. Oh, hey. I-9, let me go.